At 6:23 in the morning on May 11th, 2026, the Supreme Court of the United States did something that 50 years of gun control advocacy, billions of dollars in lobbying, hundreds of legislative battles, and thousands of courthouse arguments could not prevent. They struck down every firearm permit requirement in America, every single one, not most of them, not the controversial ones, every permit requirement, every ownership license, every waiting period dressed up as a safety measure, every training mandate sold to you as a condition of your own constitutional rights, gone, eliminated, declared unconstitutional in a single ruling. This is the most consequential Second Amendment decision since the Heller case 18 years ago, and I'm going to tell you exactly what it means and exactly what it does not mean. Exactly who is already working to undo it tonight, and exactly what you need to do right now before your state government tries to slide the same restriction back under a different name. Because that is already happening. As you watch this, people in state capitals across America are drafting legislation. Subscribe right now and turn on notifications, because this channel tracks what governments actually do when courts force their hands, and what is coming in the next 6 months will define gun rights for the next generation. The case is called National Association for Gun Rights versus United States. And if you have only heard cable news describe it, you have probably heard either that the Supreme Court just armed every criminal in America, or that the Supreme Court just liberated every patriot from government tyranny. Both of those framings are wrong, and both of them are designed to make you feel something rather than understand something. So let me tell you what the court actually held in plain language, because the legal principle here is genuinely important and genuinely simple. Once you strip away the noise, the Second Amendment, the court ruled, protects a pre-existing individual right. The government did not create that right. The government cannot condition the exercise of that right on obtaining bureaucratic permission. That is the core holding. Read it again slowly, because everything else flows from it. The government can verify whether you are legally eligible to exercise a right. The government cannot make you ask for permission to exercise it. Those are two completely different things, and the court just drew a bright legal line between them that every gun control advocate in America spent decades trying to blur. So here is what that distinction means in practice. A background check is verification. You walk into a federally licensed firearms dealer. The dealer runs your information through the National Instant Criminal Background Check System. The system confirms you are not a felon, not a domestic violence convict, not subject to a restraining order, not adjudicated mentally ill by a court. The system clears you. You take your firearm home. That process is legal under this ruling. That process is constitutional. The court explicitly said verification is permissible. What is no longer permissible is the permission system that sat on top of the verification system in state after state across this country. The system where you had to file an application and wait weeks or months for approval, pay fees that had nothing to do with the actual cost of a background check, submit to discretionary review by government officials who could deny you for reasons that were never clearly defined, take government-mandated training courses before the state would grant you the privilege of exercising what the Constitution calls a right. That entire architecture, the application, the waiting, the approval, the fee, the discretion, the mandate, that is what the Supreme Court just declared unconstitutional. Because when government can make you wait indefinitely for a right, government effectively has the power to deny the right. And a right that can be denied by bureaucratic delay is not a right at all. It is a government-granted privilege. And the court said the Second Amendment does not work that way. This is not a radical legal theory. This is foundational constitutional law applied consistently to a right that has been treated inconsistently for half a century. The First Amendment does not require you to apply for a permit before you speak. The Fourth Amendment does not require you to obtain government approval before you refuse a warrantless search. The Fifth Amendment does not require you to file paperwork before you decline to incriminate yourself. The Second Amendment now joins those rights as a right you exercise without asking permission first. That is the decision. That is what changed this morning. Now let us talk about geography, because this decision did not land equally across the country. In 25 states that already operated under constitutional carry laws, states that never required permits to begin. With this ruling as confirmation and protection, it makes it significantly harder for future legislatures to reimpose permit requirements because now there is a Supreme Court precedent directly on point. But in 43 states that maintain some form of permit requirement, this ruling is seismic. And in the states that built their entire identity around gun control permitting systems, it is nothing short of constitutional demolition. Massachusetts is devastated, and there is no softer way to say it. The Bay State built a two-tier licensing system that was the envy of every gun control advocate in the country. You needed a firearms identification card just to possess a long gun or low-capacity handgun. You needed a license to carry to possess a handgun with normal capacity magazines or to carry anything concealed. Both of those licensing systems required application, waiting periods, chief of police approval, and fees. Both of them are now unconstitutional. The foundation of Massachusetts gun policy just collapsed overnight. New York's situation is equally severe and arguably more politically explosive. The New York City Pistol Licensing Board operated with essentially unlimited discretion. You had to demonstrate proper cause to carry a concealed firearm in the city. The licensing board could decide your reason was not good enough and deny you. This is the exact discretionary permission system the Supreme Court already began dismantling in Bruin back in 2022. This new ruling finishes that work completely. You can carry concealed in New York now. No license, no proper cause test, no licensing board making subjective decisions about whether your reason for wanting to protect yourself meets their standards. Illinois maintained the Firearm Owner's Identification Card System, the FOID, and it was one of the most comprehensive gun owner tracking systems in any state. Every person who wanted to own a firearm or ammunition in Illinois needed a FOID card. You had to apply, you had to be approved. The state maintained a database of cardholders. That system was not just a permit, it functioned as a registry. It gave the state a comprehensive list of who owned firearms. That system is gone. California's waiting periods beyond the time needed to complete a background check are gone. New Jersey's handgun purchase permits are gone. Connecticut's licensing system is gone. Delaware's permit requirements are gone. Rhode Island's licensing requirements are gone. Maryland's permitting system is gone. Across the northeastern corridor that built gun control as a signature policy achievement, the legal infrastructure that supported it has just been declared unconstitutional, and not by a close vote, by a court that has been building to this conclusion through a series of decisions that anyone paying attention could see coming. Before we go any further, I need to be precise about what this ruling does not do, because misinformation is already spreading in both directions, and both versions of the misinformation are dangerous. The ruling does not mean you can own or carry a firearm if you are legally prohibited from doing so. Federal law still disqualifies convicted felons. Federal law still disqualifies people convicted of domestic violence, misdemeanors. Federal law still disqualifies people subject to active, protective, or restraining orders. Federal law still disqualifies people adjudicated mentally ill by a court. Federal law still sets age minimums 18 for long guns, 21 for handguns. None of that changed. All of that remains in full force. Background checks still happen. Federal firearms licensees still run NIC's checks on every sale from a licensed dealer. The verification system is intact, and what is gone is the permission system layered on top of it. Sensitive place restrictions also remain constitutional. I want to be clear about this because people are going to test this and they are going to get arrested and they are going to deserve it. You cannot carry into federal buildings. You cannot carry into courthouses. You cannot carry into schools under the Federal Gun-Free School Zones Act. You cannot carry into airports beyond security checkpoints. These sensitive place restrictions have a separate constitutional analysis, and this ruling did not disturb them. The court distinguished between carrying generally in public, which you can now do without a permit nationwide, and carrying in specific locations where heightened government interests justify restrictions. Do not test sensitive place restrictions. They are still enforceable. Getting arrested to make a point is not a practical exercise of constitutional rights, it is a criminal record. What the ruling changed is the general framework. Ordinary law-abiding Americans who could pass a background check no longer have to beg their state government for permission to exercise a constitutional right. They do not have to wait. They do not have to pay fees beyond the actual cost of the background check. They do not have to complete government-mandated training as a condition of exercising their rights. They do not have to submit to discretionary review by officials who could deny them for subjective reasons. The permission slip is gone. The verification process remains. That is the actual change, and it is enormous. Here is where I need you to pay very close attention, because what comes next is arguably more important than the ruling itself. Every government official in every restricted state is looking at this decision tonight and asking one question. Not how do we comply, not how do we respect this constitutional ruling. The question they are asking is how do we accomplish the same goal under a different legal name. That is not cynicism talking. That is how government institutions actually respond to court decisions that constrain their power. They transform, they adapt, they find new language for the same restriction, and they hope the courts do not notice or do not care. The Brady campaign is already talking about alternative frameworks. Everytown for Gun Safety just announced what is being described as a $50 million campaign for new approaches to gun safety legislation. The gun control industry is not accepting this decision. It is strategizing around it tonight with the same energy and resources it has been deploying for 50 years, and the workarounds they are considering are sophisticated enough that ordinary gun owners need to understand them in advance. Registration systems are the most immediate threat, and I want to explain precisely why. The permit system says you have to get government approval before you exercise your right. The court just said that is unconstitutional, but a registration system says you just have to tell the government what you own. No approval required, just notification. And some people look at that and think that sounds reasonable. What is the harm in the government just knowing? The harm is that a comprehensive government registry of firearm owners is the necessary precondition for confiscation. It is not a slippery slope argument. It is a historical fact demonstrated in multiple countries and multiple American cities that have attempted it. If the government knows who owns what, the government has the operational capacity to seize what to it too. Knows about registration is not safety. Registration is inventory for future enforcement. Ammunition licensing is the second major workaround being discussed. The court ruled on firearms. It ruled on permits and permission systems for purchasing and carrying firearms. It did not specifically address ammunition, so you will see proposals that say you can own a gun permit-free, but you need a license to purchase ammunition. Same practical effect, different legal hook. Expect it, challenge it. The same constitutional principle that makes firearm permit requirements unconstitutional almost certainly applies to ammunition licensing, because a right rendered practically unusable by licensing the necessary components of exercising that right is still a right being denied through a government permission system. But that legal argument will need to be fought state by state, case by case, and it will take years and millions of dollars in litigation. Safe storage mandates with government inspection authority are the third major workaround coming. California and Massachusetts have already floated versions of this. The argument will be that you can own your firearm without a permit, but you must store it in a government-approved manner and be subject to inspection to verify compliance. The inspection component is the constitutional problem. Government cannot use a safety rationale to create de facto registration and surveillance of firearm owners in their homes, but expect them to try. Every single one of these workarounds is coming. Every single one will require litigation to defeat. And the gun rights organizations that just won this battle are about to fight the next 10 simultaneously. To truly understand why this decision matters and why it was always coming, you need to understand the legal journey that produced it, because this did not happen in isolation. This was the culmination of a constitutional argument that has been building across 3 landmark Supreme Court cases over 18 years. In 2008, the Supreme Court decided District of Columbia versus Heller. That case was the foundation, the court held for the first time explicitly that the Second Amendment protects an individual right to keep and bear arms for lawful purposes, including self-defense, and that this right is not limited to militia service. Heller overturned a Washington, D.C. handgun ban and established that the government cannot simply prohibit civilian firearms ownership, but Heller left enormous ambiguity. The court said states could still have reasonable regulations. It gave almost no guidance on what reasonable meant, and for the next 14 years, lower courts used that ambiguity to uphold virtually every gun regulation they reviewed by simply declaring it reasonable without rigorous analysis. In 2010, the court decided McDonald versus City of Chicago. McDonald incorporated the Second Amendment against the states through the 14th Amendment. Before McDonald, some legal theorists argued Heller only applied to federal enclaves like Washington, D.C. McDonald ended that argument. The Second Amendment now applied everywhere in America as a constitutional constraint on state and local governments. But the reasonable regulations language from Heller still left states enormous room to operate. They maintained permit systems, they maintained waiting periods, they maintained training mandates. All of it survived judicial review for over a decade because courts were using an interest balancing test that weighed government interests against individual rights, and under that test, government almost always won. Then came Bruin in 2022. New York State Rifle and Pistol Association versus Bruin changed the entire analytical framework. The court threw out the interest balancing test that had allowed permit systems to survive for so long and replaced it with a historical tradition test. From that point forward, any gun regulation had to be rooted in America's historical tradition of firearms regulation at the time of the founding. The relevant question was no longer whether the government had a good reason for the regulation. The relevant question was whether similar regulations existed in 1791 or 1868, and permit systems did not exist in 1791. They did not exist in 1868. They are 20th century inventions designed to control access to rights that the founders explicitly protected without conditioning on government permission. Bruin opened the door. This new ruling walked through it completely and closed it behind them. The logical progression from Heller to McDonald to Bruin to this ruling is not a conspiracy or a coup. It is a constitutional argument that was always going to reach this conclusion if the court applied the historical tradition test consistently. Today they did. So where does that leave you? And what do you actually do with this information right now? Today, before your state legislature figures out its response strategy and before local law enforcement gets guidance from attorneys general who are already spinning up legal challenges, let me give you a clear, honest, practical framework, because the confusion of the next 30 days is going to be real and people are going to get caught in the middle of it. First, verify your own legal status before you do anything else. This ruling changed the permission framework. It did not change who is prohibited. So if you have felony convictions, if you have domestic violence convictions, if you are subject to an active restraining order, if you have been adjudicated mentally ill by a court, this ruling does not help you. You are still prohibited under federal law, and exercising rights you do not have is a federal crime. Know your own status before you walk into a gun store. Second, if you are not prohibited, understand that you can now walk into a federally licensed firearms dealer, pass a background check, and purchase a firearm without a state-issued permit in any state. The permission layer is gone. The background check layer remains. Go through the background check, get your clearance, document it, keep records of every firearms purchase with dates and background check results, because documentation of legal compliance matters. When states begin arresting people for violating new systems they have not yet invented, but are definitely inventing right now. Third, respect sensitive place restrictions, absolutely and without exception. Federal buildings, courthouses, schools, airports beyond security, these are still restricted, and the restrictions are still enforceable. The goal of exercising your rights is not to create a confrontation that results in a criminal record. The goal is to live freely within the actual boundaries of the law. Know those boundaries. Fourth, get training voluntarily. The government can no longer mandate training as a condition of your rights. That does not mean training is unnecessary, it means it is your responsibility. Now, rather than a government checkbox. If you are going to own a firearm, you have an obligation to be competent with it. Get trained, practice, understand the legal framework of self-defense in your state. Freedom and responsibility are not opposites. They are the same thing, expressed differently. The government just got out of the way. That means the accountability is yours. Fifth, support the litigation organizations that just won this battle and are immediately entering the next one. The Second Amendment Foundation, the Firearms Policy Coalition, Gun Owners of America, these organizations spent years and millions of dollars getting to this decision, and they're going to spend years and millions more defending it against every workaround that state governments devise. Register systems, ammunition, licensing proposals, safe storage inspection mandates, whatever new language gets invented for the same old restriction. Every one of those fights requires legal resources, competent attorneys, and cases that make it to the Supreme Court. If you benefit from this ruling, you have a stake in defending it and support the organizations doing the legal work. Sixth, and finally, understand the political stakes with clarity. This decision happened because of 3 Supreme Court appointments made during the Trump administration. The court composition shifted and the jurisprudence shifted with it. Future appointments could shift it back. A future court could narrow this ruling, distinguish it, or in an extreme scenario, reverse it. That is not hypothetical. That is constitutional reality. The 2026 midterm elections and every federal election after them are partly about who appoints the next generation of federal judges. You need to understand that and vote accordingly, not as a partisan, but as someone who understands that constitutional rights are only as durable as the courts that protect them. Here is the bottom line. As of this morning, the era of asking your government for permission to exercise a constitutional right is over. Over 50 years of permit requirements, licensing systems, waiting periods, and discretionary approvals just got declared unconstitutional in one ruling. That is historic. But history is not self-executing. The people who built those systems are not going away. They are restructuring. They are rebranding. They are looking for new legal hooks for the same old restrictions. Your job is to stay informed, stay legally compliant, support the organizations fighting in court, and hold every elected official accountable when they try to slide a registration system past you and call it something else. The permission slip is gone. The fight is not, and I will be here tracking every single development as it happens, every state bill, every legal challenge, every new workaround attempt, every court ruling that builds on or chips away at what the Supreme Court decided this morning. If you want to stay ahead of what your government is doing when it thinks you are not paying attention, subscribe right now, hit the notification bell, and share this video with every person you know who needs to understand what just changed. Because the next 6 months are going to move fast, and the people who understand what is happening will be far better positioned than the people relying on cable news to explain it to them. Stay sharp, stay informed, and stay ready. This is just the beginning.